Good morning. Welcome to Prison Professors. I'm here again with our friend John, who has a really depth and breadth of experience with the Bureau of Prisons. How long did you work with the Bureau of Prisons, John?
Yeah, good morning, Michael. I worked with the Bureau of Prisons for 24 years.
24 years. And you, when you left the Bureau, you were in charge of what division?
Correct. When I left the Bureau of Prisons, I was the administrator for the Residential Reentry Management Branch, in charge of all the community-based programs nationwide.
So I asked John to come on our program to help us understand a little bit more about the computation sheet. And now we're going to try some technological wizardry to see if I can share a screen with you. So I'm going to share my entire screen, and hopefully it will record everything that I'm sharing with John. So this should be my screen right now. And can you see on my screen right now a computation sheet, John?
Yes, I can.
Great. I hope that our viewers can see it as well. If not, I'll find a way to use some editing software to show it. What I was hoping that we could do, John, is just kind of scroll through it step by step and help people understand. I blacked out the name of the person so I wouldn't be putting him on our YouTube channel. But effectively, this section at the top of the form right here is just his registration number and name. And then you scroll down and you'll see some other identifying information. Could you tell us the significance of detainers, John?
Yeah, detainers just means it would indicate, yes, if the Bureau of Prisons does have an active detainer on file, meaning that some other jurisdiction is going to take custody of the individual at the completion of their federal sentence, or no, there is no detainer, that the individual will release to their term of supervision at the completion of the federal sentence.
And what's important for people to realize is there's, in every law library in prison and through our website, you will find a form the Department of Justice publishes called the Interstate Agreement on Detainers. If you have a detainer, if you have an outstanding case, if you think there's something going on in your life from, you got a DWI that was never resolved or some type of court criminal matter that was never resolved, that is what a detainer is going to reflect. If you have one, you're not going to be eligible for a lot of programs. So you want to make sure you resolve that as soon as possible. And you can do that through the Interstate Agreement on Detainers. And there's another section on our website which shows you how. So John, you have this other section here I see that says age 65. Could you explain how that's relevant to the elderly offender program?
Yeah, specifically, as you indicated, the age, you have to be over 60 to be eligible for the elderly offender home detention program. And the age is extremely relevant just for that program specifically. Yeah,
and if they are over 60, and they do qualify for the elderly offender program, what is the benefit that they get?
Yeah, so if they are over 60 and they qualify for the home detention eligibility or the elderly offender home detention program, if they have served the appropriate length of time, so 2/3 of their sentence, they may be able to serve the remainder of their time on home confinement.
And if we continue working our way down here, these quarters just shows where the person lives inside of the institution. And that's probably C unit, row 2, bunk 37 lower, from my experience. What does notifications mean, John?
Notifications is a couple of different things. It's notifications required under the Law Enforcement Officer Safety Act, or it's notifications under where you have a victim and the victim is required to be notified. So you committed a crime where we're required, or the Bureau of Prisons is required to notify the law enforcement in the jurisdiction that you're releasing to of your release date, or also if there's specific victim information that require notification.
And that might be something for some people that would be relevant when they're creating their release plan. We've spoken a lot about the importance of developing a comprehensive release plan. I don't know if it's relevant, but it's good to know that that's what notifications mean. It's always, in my view, it's always good to know how the unit team is going to be interpreting these documents, and now I know what notifications mean. If we scroll down here to say FSA eligibility status is eligible, Could you help our audience understand what that means?
Yeah, that line right there is very critical to your release plan. So under the First Step Act, those that are either minimum or low custody are eligible to earn time credits towards early release or early placement in the community. So just showing that this is eligible means that this individual is eligible to earn those earned time credits, whether that be 10 days or 15 days a month, for participation in programming within the Bureau of Prisons.
And just so that we're clear, you said 10 or 15 days. That is related to the person's pattern score, which we have more information on the pattern score. But is the 10 days applied to people who score low on the pattern score and 15 to the people who score minimum on the pattern score? Is that an accurate interpretation?
Generally, yes.
So generally, so there are cases where it's different?
There are cases where an individual may be currently at a low that is up for a reduction that may get those additional time at a specific, once their custody level is downgraded.
I see. So if somebody scores low and they participate in approved programs and they meet all the appropriate criteria, does that mean they will earn 10 days while they're a low, but a year later, because of their good behavior, they drop to a minimum on the pattern score? Would the earlier credits transition from 10 to 15 days, or would it remain as 10 and all future credits go to 15 days?
Yes, you get the credit for the programming for the security level that you are at the time the credits are awarded. So it would be 10 until you drop down to the minimum, and then you'd get 15.
I see. Okay. And so the following sentence status for the inmate's current commitment, and this says the home detention eligibility date of April 22nd, 24 is, could you tell us what that relates to?
Yeah, that home detention eligibility date is that 6-month, 10% date where they will be eligible for home confinement under normal conditions. So if none of the other statutorily programs such as CARES Act or First Step Act, or if no earned time credits, that is the date that they'd be eligible for home detention under 1836-21.
And for that is the second chance. Is that what the Second Chance Act provides? 10% of the sentence length, or 6 months, whichever is less. Is that right?
That is correct.
So because this person only had a 34-month sentence, this person, the maximum home confinement date would be 3.4 months, correct?
Correct.
Okay. And if the person had a 60-month sentence, then that person could serve up to 6 months on home confinement, but 12 months in a residential reentry center. Is that accurate?
That is accurate.
Okay. So, but you've spoken with us before about the difficulty of the residential reentry centers, that there's a real scarcity of space. Could you remind our audience about what that means, that how difficult it is to get the 12 months in a residential reentry center?
Yeah, the space available in residential reentry centers is a finite number. There's only so many residential reentry centers nationwide, and especially in those major metropolitan areas where there's a large number of releases, it's very difficult to give somebody the full 12 months simply because there's not the resources available in the community. And it's very difficult to obtain new resources in the communities due to zoning and other legal restrictions on siting of halfway houses. So that finite number, the Bureau of Prisons and our contractors do a really, really good job in managing the space and maximizing the amount of time an individual can get. But there are times, due to the resources available, that you will not get that full 12 months if you're actually recommended for it and eligible for the full 12 months.
And that goes to the importance of developing a really strong release plan that John spoke about in our previous interview, so that you can develop a good relationship, hopefully, with your unit team and also the residential reentry manager who makes that determination of who gets that scarce space. Is that am I representing what you said accurately?
Yes, Michael, I think it's incredibly important that you articulate in writing to your case manager and other folks involved in your release planning why you feel you need the amount of time that was recommended and what you're going to do at that time, how you're going to be productive during that time, and really strive to be very, a good reentry plan.
And we have here the inmate is projected for release via GCT release. Could you help us understand GCT release?
Yeah, good conduct time release is the release that's been adjusted by the amount of good conduct time days that you have earned and that are vested, so that up to 54 days a year of good conduct time that can be earned, that release date has been adjusted by those projected good conduct time days.
And we see in this person's the example here that this person had the date that the sentence was imposed was January the 18th. We see that the date that the person was committed to the Bureau of Prisons is March the 4th. And this comes into play, I think, a little bit later, where we see some information about jail time credit. Could you, let's see, that's kind of self-explanatory there. Scroll down. Oh, we have something that's very important here, this fine, a felony assessment and the fines. And what is the Bureau of Prisons going to require for people who have some type of financial sanction associated with their sentence?
Yeah, the Bureau of Prisons will work with the individual when they come into incarceration, and they'll come up with a plan, a restitution plan on how to pay those fines. And it's incumbent upon the individual to do everything they can to reduce that fine as much as they can during their period of incarceration. You just don't want that fine hanging over your head or still pending upon your release.
And we have a rather lengthy webinar where we speak about the financial responsibility plan and how you could be in compliance and why it's so important to be in compliance. You may not be able to pay the $25,000, but if you're in compliance with the plan that your unit team puts forward, at least you're going to be what's called FRP participate. And if you don't participate, what happens if you don't participate in the FRP plan?
If you do not participate, you may not be eligible for placement in the community, and there may be some other sanctions that you will not get some of the benefits of early release or time credits.
And we have here a sentence procedure, section 3559 PLRA sentence. Could you help them understand how the Bureau of Prisons uses that designation?
Yeah, that is simply the procedure which you are sentenced. In this case, it's a 3559 Prison Litigation Reform Act sentence. Just means it happened after a certain date. And different sentencing procedures may be used for different crimes. You may be sentenced under the Uniform Code of Military Justice for military prisoners. Different sentencing procedures that are in place at the time of your sentence.
Yeah, and the benefits that accrue to you relate to that type of sentence procedure. I was sentenced under what's called the old law, pre-guidelines or pre-comprehensive crime control act sentence. Everybody today is going to be under this Prison Litigation Reform Act sentence as of where are we, in August of 2022, correct?
That is correct.
Yeah. So if you're watching this webinar as a justice impacted person going into the sentence, this is the law that applies to you. And the First Step Act is a big part of that now. Does the First Step Act apply to every person in federal prison, John?
No, it does not. The First Step Act, well, yes, it applies to every person that's in federal prison, but how it applies is different based on the nature of your crime. And for example, if you're committed of a crime of violence, even though the First Step Act applies, you may not get earned time credits for program participation based on your security level and the type of offense.
Yeah, so it's important to realize that if you're in federal prison, the earned time credit only goes to people who have that low or minimum pattern score, but you still have access to provisions of the First Step Act that didn't exist before the First Step Act. For example, you now have the ability, if you document your journey well and you can demonstrate you've got an extraordinary and compelling story and other factors apply, you at least have the ability to go back to your sentencing judge on a compassionate release motion, provided you go through administrative remedies and all those kinds of things. That didn't exist before the First Step Act. And that's something to be thinking about. Even if you have a very long sentence, there are reasons to avoid disciplinary infractions, participate in the FRP program, and have a really well-documented release plan showing how you're changing, because that might be something that can make an impression on a judge several years down the road. At least there's been many people that have gotten that benefit, and I would encourage you to learn as much as you can. Even if you don't qualify for earned time credits, there are ways that you can benefit. Would you agree with that, John?
Yes, absolutely, Michael. I think there's a lot of provisions under the First Step Act that really provided for good quality programming for everybody who's incarcerated. And taking advantage of that programming and developing a good, solid release plan, even absent the earning of earned time credits, is still going to go a long way towards extending your time in halfway houses and in release programs based on your desire or willingness to succeed.
It's so important to be looking at the stakeholders like John, who used to be in charge of the home confinement program and the residential reentry centers across America. It's important to think about the case manager you're going to meet in the future, the warden you're going to meet in the future, the probation officer you're going to meet. All of these are stakeholders that have enormous discretion over your life. And to the extent you document your story of what you're doing, you could turn, a 34-month sentence into an earlier release date than somebody who doesn't. And if you have a 340-month sentence, a very long sentence, it's equally as important to not only be thinking about today, but think about the months and years ahead and what's going to be different in your life, because that's what stakeholders are going to be looking at, particularly in this era of the First Step Act. We have some information that this person had a 34-month sentence. He has followed by 3 years of supervised release, and this offense occurred on October the 28th of 2020. Now, there's a second page on this computation sheet where you start, and John, you'd mentioned that this computation sheet, which was prepared relatively recently, but it doesn't have on here the provisions of the First Step Act and the time credits, and that we'll get to that section. This was updated in April of 22, so a couple of months ago. And do you have any indication on when the new computation sheets will include First Step Act?
Yeah, it's my understanding that the Bureau of Prisons has targeted October 1st as the date that First Step Act time credits will be added to the sentence computations. It's important to note, Michael, as you said, that this computation was last updated on April 12th. That was prior to the final rule on First Step Act credits being published in the Federal Register or being done. So now that final rule has been published, it's my understanding that the Bureau of Prisons is working to include the time credits into the sentence comps, and that's going to happen. They're targeting about October 1st, but my guess is that will occur prior to the end of the year.
Yeah, and that's something that everybody should be thinking about, is if you don't see it on your computation, if you're looking at this, you're a family member who has a loved one in prison, or you're going into prison, and let's just say it's not even done by October 1st, you said by the end of the year, it may be the spring of next year. What I can tell you, as somebody who's gone through a lot of reform movements during the journey, is this is iterative, but it is going to be retroactive. The law does hold that if you're participating in the programs and you do qualify, the Bureau of Prisons will give you credit for it, even if you don't see it on your computation sheet right now. Is that accurate, John?
Yeah, Michael, you bring up a really good point. The Bureau of Prisons, to my understanding, is calculating earned time credits on an individual basis right now, with priority on those who are going to release the earliest. So if you're looking at your sentence computation and you believe that you've earned enough earned time credits that you should be transitioning either to early release or to a halfway house, it's incumbent upon you again to talk to your case manager, talk to your unit team staff, and ask them, how many earned time credits have I earned? Here's what I calculate that I should have earned by now. Do you agree with that? And if so, can we get my sentence computation updated to reflect the earned time credits so that I can get the maximum amount of time either towards early release or in a halfway house or home confinement based on the program participation that I have done to date?
And again, it's all the more reason for a person to develop a good relationship with the unit team. I found unit team members to be helpful to me that in ways that they weren't helpful to people that maybe perceived as that they perceive as being problematic or causing trouble. When I went to prison, I remember my unit manager and the first unit team telling me I would never leave a United States penitentiary. But over time, you develop a relationship, and it was a unit manager that put me in for a management variable and sent me to minimum security camps and got me out at the soonest possible time, and I had the highest level of liberty. I want anybody that's working through these programs and these courses that we offer to understand the relevance of your behavior today and how could potentially influence your life in the months, years, and even decades ahead. You've always got to be looking ahead and thinking about the stakeholders that are going to have influence over your life. And that's where we can kind of scroll through here. You can, even if those earned time credits aren't available today, you should be participating in the courses. You should be doing everything possible, knowing that it's a huge bureaucracy and it may take some time before this completes. But if you ask your case manager, according to what I just heard from John, that case manager may be able to prompt who does these computation sheets, John? Is it the case manager?
No, the computation sheet is done by the Designation and Sentence Computation Center down in Texas. And the case manager is feeding information or entering in program participation information towards those earned time credits. And then once those are in, the DSCC is responsible for updating the sentence computation.
And what they're going to be entering, this is basically a database, and that's what they're rebuilding. What he'd said that they're going to rebuild hopefully by October or sometime before the end of 2022, that the case manager, whoever is entering the information into the case management system, they'll put dates in there, like this person began on March the 4th, 2022. Is that the day the person surrendered to the Bureau of Prisons?
It is. Normally, that's the date they came into custody or the date they surrendered to the Bureau of Prisons.
And then they will just enter in there the date of 34 months. You can see that they convert that date to 2 years and 10 months. And the earliest date of the offense. What is that? Is that relevant for some reason to this form, John?
So the earliest date of offense is relevant because you can't get credit for time that was served prior to the time you committed the offense. So it's simply a calculation date that they're using when they're doing jail credit. So if you committed the offense, in this case, on October 28, 2022, but let's say you were in jail for an underlying offense prior to that date that you were not convicted of, you did not receive a sentence. Well, you cannot receive jail credit for any jail that you did prior to the offense date on the instant offense. The underlying, anything you were serving jail for prior to that date, you will not get the jail credit for. And it's pretty rare.
Well, there could be potentially another factor, and I'd like you to get your comment on that earliest date of offense is qualification. If you qualify for RDAP, the system is going to be looking. My understanding is the system is going to be looking at when is your most recent documented history of substance abuse, and it has to be within 12 months of the day of your arrest. Is that accurate, John? And does that offense date relate to that pre-sentence investigation when you're indicating the most recent document. It's my understanding that you have to have a substance abuse documentation within 12 months of the date of your arrest. Is that accurate?
Yeah, it can relate to that, and they can use this date for that. However, for RDAP purposes, they're generally going to use the information contained in the pre-sentence report versus the information contained within the sentence computation.
Okay. And then jail credit. Remember that what does jail credit mean, John?
So jail credit is any time that you served in a jail or prison setting after the date of offense that you were serving in a jail or a prison, not in the custody of the Bureau of Prisons. So generally, this is time spent in marshal's custody in a jail while you're awaiting sentencing or awaiting transfer to the Bureau of Prisons.
And notice here that it has 1 day of jail credit. So even if you surrender, you're in the custody of the marshals, which is the day that you get fingerprinted, the day that you may change your plea from not guilty to guilty, you get credit for that 1 day, even if you're only there for a couple of hours. Is that accurate, John?
Absolutely.
So it's important to realize that any time you're in custody, that applies to your sentencing date. And then this inoperative time, what does that mean? Something like you're in custody for a different offense?
No, inoperative time is time where you came into custody of the Bureau of Prisons, and generally this is an individual who's escaped or walked away from Bureau of Prisons custody. So you did not show up to the halfway house. They wrote you an incident report for escape or failure to show up. And they're going to put you in inop time or inoperative time for the period or the duration that you're unaccountable for.
So we have then go on there to the total good time earned and projected. What is the difference between earned and projected of total good conduct time?
Yeah, so total good time earned and projected in this case is the 153. So if you take the 34 months, you divide that by 12, and then you multiply it by 54, you're going to come up with 152.9 or something like that. They rounded up to the 153 days, which is the amount of time that you could get for your entire length of incarceration, your entire sentence. You could get 153 days. The total good conduct time earned is that time that you've actually earned and is vested. So if you've done 6 months, that will show a lesser date. It'll show, if you've done 1 year, that'll probably show 54 days. That's just the total amount of time you can earn and project it, and then what you've actually earned.
So if somebody's sentenced to 34 months, the 15% that they can earn, is that projected? Or like when I went to prison, I was under a different sentencing law, and I got 5,400 days of statutory good time the day I surrendered to the Bureau of Prisons. It could be taken away, but it was already applied the day I came in. It's different now, isn't it, with the PLRA sentences? Is it projected, or do they give you that credit as soon as you come in?
So it's projected at that point in time. The minute you come in, it's projected, and then you earn it at the rate of 54 per year served.
Okay.
54 days. So that's the difference.
Okay. So assuming somebody doesn't receive any disciplinary infractions, and this person had a 34-month sentence, that the projection would be that 153 days. As long as he doesn't get any trouble, that's what's going to come off of his sentence. Is that right?
Yeah. So if you look at, this individual's basically served 10 months at this point in time. So he has not earned any good conduct time because they're going to earn 54 days per year. So once he's served a year, you'll see that total good conduct time earned will change to that 54 days.
That's helpful. And what is the statutory release date?
So the statutory release date is the release date that you would be released if you served the entire term of incarceration with no time off for good conduct time. No, sorry. Statutory release date is the date that you're projected for release with the good conduct time.
So the expiration of the full term date, that is the one that would be if you earned no good time. Is that accurate?
That is correct.
Okay, so there's the two different statutory release date projected. And that's assuming you're going to do well and not lose any of these benefits of good time. And then expiration full term is if you got into trouble and you lost your good time, you can see the difference. It's between August of 24 versus January of 25. So you'd be in prison for several months longer if you violated rules or you lost those good time. And the elderly offender 2/3 date, does that take into consideration the good time, or is that off of the 34-month sentence?
So the 2/3 date is the 2/3 date of the full sentence. So the 34 months.
Okay. And then you'll see these percentages are going to change as calendar pages turn. The more percentage the more percentage you have in completion of the more months you serve, the more you're going to have served. And that applies right now under what would we call that? This weird kind of time where you have a CARES Act eligibility. Is that what percentages matter?
So CARES Act eligibility, although I know it's important to individuals, CARES Act is very discretionary. So CARES Act is a specific authority that was granted to the director of the Bureau of Prisons to mitigate the effects of the COVID-19 pandemic. So CARES Act could end tomorrow. Again, whenever the president makes a determination that there no longer is a national emergency, the authorities under the CARES Act can end. So CARES Act is extremely discretionary. If you get submitted under CARES Act, the Bureau of Prisons has the discretion to place you in the community earlier than these statutory dates on your sentence computation. But because it's discretionary, it's not in your sentence computation. That's something that's individually worked out on an individual basis based on the risk for contracting COVID-19 and the risk associated with the facility that you're at. So I tell everybody, although CARES Act is incredibly important, that's not something you can rely on. Your sentence computation and the statutory authorities granted in your sentence computation is what you can rely on. The CARES Act is something that, while the authorities are in place, the Bureau of Prisons has the discretion to do, and they're doing it very, very well, in my opinion. They're utilizing all the resources they can to place individuals under the CARES Act, but it's not something that you're guaranteed.
So again, the importance on every individual going into the system is to be thinking about how are you documenting your journey, including your potential vulnerability to care. So your disciplinary history, your participation in the financial responsibility plan. These relate to CARES, but they definitely relate to the First Step Act, which is a law that is not going to be taken away. That would require a new act of Congress or something. Whereas if the pandemic ends and it's no longer declared a pandemic, as John said, it's discretionary. It will vanish. So just always be thinking about what steps you can take if you're going into that system to influence this outcome. And again, this particular computation sheet does not reflect the earned time credits. Not everybody's eligible for them. You have to have a low or a minimum pattern score, but you definitely want to be participating in programs, because it will, if you have the earned time credits, how will that influence release dates? John, let's just assume somebody is earning the 15 days a month and they're participating in programs. What is the maximum benefit they could receive under the First Step Act and participation with earned time credits?
Yeah, so if you're earning earned time credits, the current rules language allows for the first 12 months of those earned time credits to generally be applied towards early release to supervision. So meaning you're going to release from the Bureau of Prisons and be under the custody and supervision of the United States Probation Office for up to 12 months of earned time credits. If you earn over 12 months of earned time credits, that additional time can be applied towards early placement in either a halfway house or home confinement. And when we say early placement, that's earlier placement than you would ordinarily be placed if you had no earned time credits. So if, for example, the unit team felt that you needed 4 months, but you had an extra 2 months of earned time credits, the unit team could then ask that you be placed in the halfway house or home confinement for up to 6 months.
Does that override the Second Chance Act, which only allows a maximum of 60 months or six months on home confinement? And we'd be talking about somebody that has a relatively long sentence. Let's say maybe has 120 months, and they're projecting into the future. They've done all the programs that they possibly could. They've earned the 12 months earned time credits, anything else, but they could theoretically, they've earned enough that maybe be able to participate in much longer than 6 months of home confinement. But Second Chance Act doesn't allow it. Does the First Step Act trump the Second Chance Act?
So the First Step Act actually waived the requirements under the Second Chance Act for the statutory limitations on home confinement. So yes, if you have earned time credits that allow you to exceed that 6 months on home confinement or that 12 months in a halfway house, those statutory limitations are no longer applicable to you.
And that's why it's so important to be documenting your journey, developing a strong release plan, understanding how your future unit teams will be looking at you, and just doing everything within your power to make yourself a better candidate. There's no guarantee that anything's going to happen. Nobody can promise you anything. It's the discretion of the unit team. Is that accurate?
Yes, it is.
Nobody can change the sentence. Only the judge can. And the president can commute a sentence, but the Bureau of Prisons is tasked with the responsibility of carrying it out. It's your job to learn how to advocate for yourself, not your lawyer's job, not your mom's job, not your girlfriend's job. It's your job. And so I would encourage you to be looking at our model release plan, which we're developing. I'm going to ask John to review that release plan before I publish it. But you need to be thinking about your own release plan and what is going to make you the best candidate. And John, I just want to thank you for being such a great resource to people who are going into the system. I know that we all learn a lot from you, and I want to thank you for your time.
Thank you, Michael. It's been really good talking with you again. Thank you very much.